you. Please be seated. All right, good morning. You're on Department 5's Family Law docket. I generally go in order after I go through the readinesses, and then on the strikes, I'll try to do the longer matters toward the end. If you think you're in the wrong courtroom or need assistance in some other way, please let me know. Please keep your devices muted and your cameras off until your case is called. Once your case is called, please turn on your camera and unmute your device. Introduce yourself and your parties. Ms. Petrie's indicating she can barely hear me. Is there anyone else that's having that same issue?
Love you, sir. Bye-bye.
I'm sorry, I didn't hear. If someone said something, I didn't hear it. All right, I'll just try to speak up. Okay. Regarding our strikes and setovers, we have number 5 on the docket. In re Marriage of Perkins, cause number 17301536. That's a strike. It's now a Department 4 matter. Number 7 on the docket, 2300511706, the PO case. That's a strike. It's will be on another court's. It'll be also Department 4, I believe. Number 10 on the docket is the guardianship of Aubrey Matson. That's 21400794406. That's a set over to 616. And I think that was it. Okay. As for readinesses, cause number 183008163, the McKilwain Wayne case. Are the parties present?
I'm here. It's Melissa McElwain.
Okay, do you have a camera?
And Your Honor, this is Tom Foley appearing for Stanley. I don't know if the court can hear me. I'm actually in Skamania, so I don't dare turn on my camera.
All right, I can hear you.
Okay, great.
I don't see your client on, but okay, this is on for readiness, unless the parties have reached an agreement. Miss, are you now, Miss McElwain? Are you? Sorry, no, I'm just butchering the name. Are you now represented by Mr. Dylan Trosper?
Yes, ma'am. Yes, Your Honor.
I don't see Mr. Trosper on the line yet. Why don't I recall this case? I'll give it a little bit of time.
Okay.
Okay, thank you.
Wait, Mr. Foley, sorry, really quick. Mr. Foley, do you intend on calling this case ready? I'll come back to it. I just have I've double booked on one day, so I'm trying to figure out which case to call next.
Yes, we are calling it ready.
Okay, great. All right, I'll come back to that. Number 1 on the docket is in Ray Parentage of Bartnick, cause number 133017927. Good morning.
Good morning.
Good morning, Ms. Ward.
Your Honor.
Is Jessica present? Have you been in communication with her?
No, ma'am.
Can you tell me how parenting's been going?
I've got her at my house. She hasn't missed a day of school, been to counseling every day. Reports saying that she's brightened up and she's moving forward, and just all good news.
Okay.
All good.
And so has she had any visits with Mom?
Today she goes.
She goes today?
Yeah, after school today.
Okay, and what did I'm sorry, because I don't remember.
She comes back on Monday. I pick her up from school on Monday.
Okay.
So Mom's getting her on the weekends, every other weekend.
Uh-huh.
And she hasn't missed a day of school. She's been to every counseling session except for one of them, which she called in, the counselor called.
Okay.
And then one was spring break weekend.
Yeah.
And we were out at the beach house, so.
Good.
But other than that,
Everything's been working out well.
everything's good.
Okay. And you've been getting along with Jessica?
No communication.
Okay, good. All right. Well, are you prepared to call the case ready for trial then?
Yes, ma'am.
Okay. This is the deal. I have another case that you just heard. I don't think this trial will take a significant amount of time. So I'm wondering if I can move it over to the 5:23 in the afternoon.
5:23 in the afternoon?
Yeah, it's currently scheduled for
For the
5.
morning?
Oops, sorry.
Those kids are.
5:22 is the trial date currently. I'd like to move it to the afternoon of 5:23.
Okay.
Does that work?
We can
Yeah.
do that.
Does that work for you, Ms. Ward?
Actually, on this case, for clarification, there is an order for mom to pay. It's an administrative order. However, I don't see that there's been any request from father to collect on it. So I'm not sure if he feels that he needs a court order or if he just wants to contact DCS and ask them to open it back up.
Child support.
For me?
Yeah, are you receiving child support from Jessica currently?
No.
Okay, but there's an order for her to pay child support currently. You haven't enforced it.
I didn't know I was supposed to. I thought everything was just 50-50 across the board until we got a settlement. That's how a decision on where she was going to be housed.
Uh-huh.
That's what I thought it was. I thought everything was just across the board right now. Nobody pays anything
But
to
you
anybody.
had full custody. Didn't you have custody? Who? You guys are doing 50-50.
There was actually a custodian. And the custodian, at that point, we had an order for father to pay and there was an order for
$200
mother
a
to
month.
pay.
Right.
Then the child's no longer with the custodian, so DCS stopped enforcing.
I got it.
There's still an order, it just means that the current custodian needs to go in and say, the child's with me and I want to collect child support.
Okay, so we can handle that at trial.
Okay.
Yeah, so you'll need to get, but Ms. Ward will need income from all of the parties, information.
That's actually what I'm asking, Your Honor. If there's already an administrative order in place, does he want a court order or does he just want to go to DCS and ask them to enforce the order that already exists?
Well, you can send the court order.
So the order that already exists, I'm getting really
I'm
confused
confused.
now. I thought you said the order that already existed had a custodian other than father.
Yes.
Okay, but
It's still an order for, it's an administrative order for mother to pay
okay.
the custodian.
So-
If father's the custodian, then it goes to him, but he
Okay.
hasn't ever requested it.
Okay,
At
so
least,
when
yeah.
she's saying that you can go down, I know, I can understand that.
Okay.
You can go down to DCS and let them know that the child's with you. Who is listed as the custodian? Who was the custodian before?
Elizabeth Michael, but she put something onto the system to where I can't even get in to open up her medical or anything.
Okay, so this person, who's this person?
The grandfather gave this woman access to my child's information so that
All I
could
want to know
get to
is
it.
who Elizabeth is so we can figure out how we get her off as the custodian.
I've been trying to. She's the grandfather's girlfriend, Buddy Bartunik's girlfriend.
Well, so then, sounds like Ms. Ward, this is something that needs to be handled in trial because he doesn't have an ability to, I mean, unless this court can just give an order saying he's the custodian. I don't know what, I know.
Yes.
That's what I need from them.
Yes.
Yeah.
All he has to do is take down the court order that says the child's been placed with him, and they'll accept that as proof that he's the custodian.
Right, well, we can't do that till trial, so I'll do that. We have
Oh,
trial.
so there's no order placing the child with him right now?
Yeah, there is. The one from the 20, I can send that one in. I know what
Okay.
she's talking about. I've already started the process, but I couldn't get in at first because she locked me out.
Mm-hmm.
And so they told me if I show you the order, I was going through her Melina trying to schedule dentist
okay.
appointments and everything, and I couldn't because she had me locked out of the system.
Okay.
So,
So this
now I
is-
know what she's talking about. I can send it to her. Matter
Okay.
of fact, I think I sent it this morning, those same papers.
Okay, all right, great. Sounds good. So otherwise, you won't need to be at the trial then, Ms. Warden. We'll have a half-day trial, 5/23.
No problem.
Okay.
Thank you. So that means, I want you to exchange, your witness list and your, trial, or your witness list and your exhibit list with, Jessica by 5/8, and I want you to exchange, and you'll need to file those with the clerk as well. And then I'll need you to exchange your exhibits and your trial brief with Jessica. You'll have one served upon the clerk's office and one served here as well.
So is she representation for Jessica or is she just for?
She's the state.
State.
Talking about
Okay, okay,
Just
that's what I
you and
understand.
Jessica.
Okay.
Okay?
Yeah, okay. Thank you.
All right, thank you.
Can you repeat the dates for me again?
My judicial assistant will send out
Okay.
a scheduling order, but it's 5/8 for the exhibits list and witness list, and 5/17 for the trial brief and for the exhibits themselves.
Okay.
Okay.
Thank you.
Okay. Let's see if we have. Mr. Ball, are you here on the Brazil matter?
Yes.
Can I call that matter now? And is Ms. Farr present? Okay, that's number 11 on our docket, 2140133206. I don't see Ms. Farr as present, and I don't see, that your daughter's present. What are we doing on this case, do you know? It's a date set for readiness, oh, there's Raven. It's the date set for readiness, but we don't have a, we don't have the report yet, right?
We have the report.
We have the
I think
report.
what we're asking for is Ms. Farr wanted some records, wanted the ROI from my client.
Right.
I don't think that's been provided yet.
Oh, I thought we said that the last hearing that would get provided.
I think that there's been, it's not, from what I understand from yesterday, it hasn't been provided, but I'm checking with her right now. And
Ms. Farr,
you can ask
good morning. You're on mute.
Sorry, I'm having trouble with my settings this morning. I can't even change my name there.
Oh, yeah. So did you get the ROI?
No. Raven sent me a document that she believes that I should be entitled to, but she doesn't want me to access the rest of her records.
I understand. That makes sense, Raven.
That's not true. I just gave you the one that they gave me first. I never said that I wasn't going to give you the record. I just gave you the copy that they sent me before sending their ROI out.
Okay. So this is what, you guys, this case has been going for a very long time. And I would like to just conclude, just get it done. We've done enough things around it. So, I think what I would like to do is just have us sit down together. I've taken enough sworn testimony and heard enough about what's been going on with this case to make a decision. I still would like to give you an opportunity to, give some input if you need to. So we're currently scheduled for 5/23. We have it scheduled for an all-day trial. I will go ahead and make that a half-day trial starting from 9 a.m. to 11 a.m. And we'll go ahead and take any remaining testimony that anyone thinks that this court needs to take so that I can proceed forward, and then we'll be done with the case. Is that okay? The parties?
Okay, thank you, Your Honor.
Does that date work?
Yes,
Mr. Hall? I know you
What's
can-
the date
today. I don't
5:23 in the
wanna do this
afternoon.
5/23.
I mean, in the morning. Sorry.
Right, I think that I already have that on my calendar, so we should
Yeah.
be good.
Okay, great.
Other
Ms.
deadlines.
Larson, and you have an interest in this as well?
Yeah, the state's interest is TANF, and in the previous, I think, 2 trial sets, the state has been excused from the trial just because Mother Raven has an administrative order, and it was said that if the petition was granted, she did not want to change, address child support. I think it could increase from where it is now with the 2017 order. So obviously, the state would not enforce the order if the child was with her, and if the petitioner prevails, then it's been previously stated that the administrative order would remain in place, and I'm just confirming that that's still the case and I'm not needed for this trial.
Okay, so you're not gonna try to get more child support?
No.
Yeah, that sounds accurate, Ms. Larson. Thank you so much for showing up today.
Thank you, Your
You will
Honor.
not be needed for trial. Thank you. Okay, so the court's calling this ready for the morning of 5/23. I'll have your exhibit lists and your witness list exchanged with each other. 5/8, petitioner Grandma will be 1 to 99. Raven, you'll be 100 to 199, and Mr. Ball, and then we'll have the trial brief and the exhibits exchanged on 5/17.
What was the 5/8 date?
Pardon?
What you said, 5/8 or May 8th?
May 8th, yeah. That's for the trial, that's for the exhibit list and witness.
Oh, exhibit lists and witnesses.
Sorry, yeah,
I bet
I sound
they're all
crazy.
exchanged on this.
I'm not gonna go to the 23rd trial. I'm not even gonna lie with you guys. Before my grandma died, I told her that I'm not dealing with
I'm
none of
sorry,
this.
Raven,
I'm not fighting
Raven,
her
I'm having
anymore.
hey, Raven, I can't hear you, I'm gonna need you to speak.
I can't fight my mom no more. I refuse to. You guys, it's in God's hands. You guys can make a decision. I don't want no parts in none of this. I just lost my grandma, and I'm not gonna fight my mom no more over it. So, at this point, I don't want no witnesses. I don't want no more trial. She's going to do what she wants to. Hopefully, she lets me be a part of my daughter's life, but I'm not doing it. I can't. I can't emotionally keep coming to court and doing none of this. I'm not going to. So that it's you. This is the last time you guys are gonna see me. I'm still gonna do my visits on Saturdays with her, but I'm not entertaining none of this. I love my mom dearly, and I can't handle this no more. Like it's not.
All right, Raven, so it sounds like the condolences are needed to the parties. I'm very sorry to hear that. So it looks like everybody's in a lot of pain right now, so I'm sorry to hear that. Raven, to me, it sounds like right now what you're doing is you're withdrawing your objection to the,
I never wanted it to go this far, Miss Banfield, and I can't. I don't want it. I just want to spend more time with my daughter, and that's it. I don't want all this extra stuff. I don't want to lose my mom from her health. I don't want to put myself in no unsafe mental health situation, and that's all that's happening right now.
right.
Like, I would do my best to try to respect my mom, but, like, it's in God's hands. I can't. Like,
Okay, I understand, and I'm really sorry. It sounds like you guys are really going through a lot right now. But Raven, when it comes to my obligation here, I have to ask specific questions, and so I'm wanting to do that. Are you indicating that you want to just consent to the guardianship now, and then you guys develop a parenting plan?
yes, I've been wanting to do that.
Okay.
That is all I want to do right now.
I understand. So what I need you to do then is I need you to reach out to Mr. Ball so he can get your signed consent. And then we have a parenting plan kind of in place right now, so we can just kind of keep that parenting plan for now, and we can you guys can bring it back in when you're ready to expand that visitation. Does that sound okay?
Yes, that does.
Well, I think what the parenting plan needs to be developed a little bit more. I'd like to just have a chance to meet with the guardian and see if we can work on some things. And
She's willing to do that, so why don't you guys sit down and do that as much as you can. I will note, and I know you're coming on kind of late, I think one of the frustrating things for the guardian has just been that, and it's not, Raven's just really been doing a ton of things to get her life together, but those things make her times that she, erratic for when she can actually be present, and so a lot of times they'll schedule things and then it doesn't follow through, so the guardian ends up changing plans because of that, so I hope you guys will take that into consideration as you prepare that. I know Raven's taken some great steps forward, so hopefully you guys can work something out. Let's just leave 523 on for entry,
Yeah.
and hopefully you'll have a signed consent and a parenting plan for me at that time.
okay, or we can try to work through whatever is remaining. Yes. Right.
Say again.
We'll work through whatever is remaining with regard to the parenting plan.
Yeah,
It should be-
I can make those decisions on
Okay.
523 in the morning.
Okay.
Right, okay,
Sounds fine.
great.
I
I'm
think
sorry,
that's where we're
Raven,
at.
so sorry for your loss. I'm really sorry. All right. I'll see you guys back on 523. Raven, if you don't want to come, you don't have to. But your attorney will be here for you, and I hope that you come because I think it'll be good to get some of your input. I'll see you guys in the morning, 523. Thank you.
Yeah, can we just talk for a few minutes?
All right. Okay. So, let's see. So let's see, Mr. Trosberg. All right. Number 2 on the docket is the Olvera matter, cause number 15-3021319.
Yes, Your Honor, just 1 second, I need to get my client
Okay.
from, the waiting room.
Ms. Hawk, are you present? Ms. Petrie, I don't see that Ms. Hawk is present at this time. Can I recall the case?
I'm sorry, say again?
I don't see that Ms. Hawk is present. Can I recall the case?
Sure.
All right,
that's
thank
fine.
you. Number, oh, it's you again, though. Number 3 on the, well, I'll see that one for later. Number 4 on the is the Ray Parentage of Reed, cause number 17-3011816. Are the parties present?
Yes, Your Honor. Good morning.
Good morning.
Good morning, Your Honor. Robin Jones, guardian of item.
Thank you. Ms. Jones, oh, go ahead, Ms. Guardino.
Thank you. Good morning, Your Honor. It's nice to meet you. I'm present as well.
Thank you. Looks like this case, we're still waiting on the GAL report. Is that right?
Yes, Your Honor. It is scheduled to be done today.
Done today. So what does that mean to the parties then?
That means that they will have it by the end of business today.
But do we have a trial date on this already?
No, Your Honor, because we wanted to take a look at the report and digest it before we set that.
Okay.
We can.
All right.
do that in real-
All right, so that report sounds like you'll be getting it today, and then once you've reviewed it, you can go ahead and reach out to my judicial assistant for a trial date.
Sounds great. Thank you, Your Honor.
Thank you. You guys have a great weekend.
Thank you.
Thank you.
Number 13 on the docket is guardianship of Zane Taylor, 23-4, 0028-406.
There should be a Vanna Taylor as well.
Pardon?
It should be.
Yes, there's 2 cases. That's a, sorry. Number 14 on the docket is regarding Vanna Taylor, 23-4-0029-106. They're separate cases. Can you introduce yourself, please?
My name is Veronica Hickman. I'm the grandma. So,
Okay. Can you spell your last name for the record, please?
Hickman.
Thank you. Will you raise your right hand? Do you swear or affirm to tell the truth in these proceedings today?
Yes.
Thank you. So my understanding, Ms. Hickman, is that your daughter, she has significant substance abuse issues. There's currently domestic violence occurring in the home. Both cases, the father is not involved in the children's.
The father's here right now, and he's been in contact with me, and he's came over to my house and visited.
Okay,
with
sir, I'll
his
have you
son.
come forward, and then when we're talking about the father, this is why you asked me. I've
Oh,
only
okay.
do one case at a time.
Okay.
So have a seat over here, sir. But
Sorry.
that's okay. Can you state your full name, sir,
Caden Milligan,
and spell your last name?
Milligan.
Thank you. Will you raise your right hand? Do you swear or affirm to tell the truth in these proceedings today?
I do.
Thank you. And you are the father of whom?
Zane Taylor.
Zane. Okay. And my understanding is that you're consenting to this guardianship?
Yes.
Okay. And right now you're dealing with some of your own issues that you still have to deal with. All right. Very good. So have you signed a consent form?
I have not.
Okay. And so if you get on to Washington Court's forms,
Okay.
they will have in the guardianship section, they will have consent form. If you could print one of those out and have Mr. sign that, I might actually be able to get one up right now. That'll just make it easier for everyone. And then, so that's regarding Zane. Regarding Vanna, her father is uninvolved. Is that
He's unknown. There's like 4 or 5 people that could be her father. So.
okay? And I'm sorry, really quick. I didn't pull it out here. How old is Vanna?
She will be 2 in June.
2. And then Zane is.
Will be 4 in June.
And so you have both of these. You did an emergency minor guardianship for. Is that
Yes,
accurate?
I did.
And then now you're petitioning for a full guardianship.
Of my grandson. my nephew and his wife were supposed to be here today, and they were supposed to Zoom, but they were up all night with my granddaughter who had a fever last night. So I'm not sure why they're not on the Zoom call right now, because I spoke to her right before and she said that she was going to. After I'd had my granddaughter for almost 3 weeks, and we had a kind of a scary incident where she was playing in the bedroom. There's Miranda.
Oh.
And the dresser fell on her.
Oh, no.
She was fine,
Yeah.
but
Yeah, it's scary. Yeah. You feel like you got a lot on your hands right now. Yeah. So, yeah. Well, you guys are doing a good job. I know that can be really difficult these times. So, ma'am, Miranda, can you please state your full name?
My name is Miranda Jennings.
Thank you. Will you spell your last name for the record, please?
Jennings.
Great. Can you tell me your relationship to this case?
I am married to Vanna's, I think they would be second cousins. So Alexa is my husband's cousin.
Okay. And is it in your intention to file a petition for guardianship?
Yes, so I was in the process of doing that, and then I was reading, there's so much paperwork that I was reading that you have to notify the parents for 20 days, and I thought, oh goodness, I think I already messed up, so.
Okay, so there's something that we call as an emergency guardianship that you could do ex parte. You don't have to give notification for that part of it because you want to hurry up and get guardianship so you can get the child to the doctor and all those things. Grandma currently has guardianship of
Right.
Vanna, so she can do all those things. That guardianship will expire soon, and so she's is deciding not, rightfully so, deciding not to file for the full guardianship on Vanna. So I'll need you to get that done as soon as possible. You can.
I actually have it, I'm so sorry to interrupt.
No, go ahead.
I actually have it written out, but Vanna's had a fever for the last
I
2
heard.
days, so.
Yeah, sorry about that.
I was able to get her to the doctors. She went to the doctor yesterday.
Good.
We had it all set up with Veronica,
Good.
faxing papers. So all of her needs have been getting met.
Yeah, that's great.
And the only thing, and I'm sorry to interrupt on this, but something very disturbing was that we found out that my granddaughter hasn't been to the doctor in like 18 months.
Yeah.
So.
Yeah, so obviously there's not parenting going on. We can see that from the application. So right now, these kids are really lucky to have family that's willing to be there and support them. So Miranda, what I'll just have you do though is when you get that paperwork filled out, you'll deliver it to Department 5, that's my department, and I will go ahead and sign off on the emergency order, and then I'll give you time to get mom served. Dad apparently is unknown in this situation, so you don't have to worry about that part, and we'll schedule a hearing so that you can get that time to get mom served. And in the meantime, as soon as you get that done, what I'll do is I will be appointing a court visitor to that case, because since we don't know the father, we have to have a court visitor kind of sign off saying, yep, we've tried to explore all the options and we're unable to determine who the father is, and then we'll be able to proceed from there. So you'll have time to get everything done. Just get that emergency one done in as soon as possible. Next week is fine, but just get it to my department. I'll sign off on that, and that'll start the process. Okay?
Thank you.
Yeah, and then for you, Mom, I've got this consent form. Jen, I'm gonna just print it to my printer, please, if you could grab it. I think this is my printer. And then if Dad could sign this, and then I'll recall your case so we can talk about it some more. So you guys go ahead and have a seat back after I get this thing. If he wants to sign the consent, I'll recall.
Okay.
All right, thank you.
Do you want me to wait for it?
Yeah, go ahead and set it. Go have a seat back there, sir. Thank you. Okay, Mr. Trosper, you're ready on number 6.
Yes, Your Honor.
Thank you. So we have Mr. Foley and Mr. Trosper. I saw that Melissa was on as well. I didn't see Dad was on. We have trial currently scheduled for 5/22. And Mr. Trosper, what I understand from Mr. Foley is that the parties are prepared to go to trial on that date.
Yes.
Good. All right. So, and everyone's received have we gotten the report from the GAL?
Yes, Your Honor.
Okay, and we're still ready, we're still wanting to go to trial.
Well, yeah, I haven't spoken with Mr. Trosper, and I'm certainly happy to do that, but I think we better have the trial as a backup.
Yeah, sounds good. Because the information I received in the report is that, the kids probably need to be with mom, basically. That's how I read through the documents. But,
Well, Your Honor, I guess my reading of it was that the children should remain in the state of Washington with father.
okay, well.
That was the recommendation of the GAL.
Oh, okay. I guess maybe I'm not. I've got some more reading to do. I guess I'd read through the counseling documents that I decided that we didn't need to disclose because I didn't think that would be helpful for the children, and that wasn't. I guess I didn't know that was the case. Do we have the GAL on right now? Okay. All right. Well, so we have trial 5/22. So we'll have you guys exchange your exhibit lists and your witness lists by 5/8, and your trial brief and your exhibits by 5/17. Mr. Trosper, you will be 1 to 99, and Mr. Foley, you will be 100 to 199.
Okay.
Thank you, Your Honor. And you said that was 5/8 for the witness list?
Yes. And the exhibit list. Yeah. Okay?
Oh,
Great,
but
thank you.
sorry, that was witnesses and exhibits 5/8.
Witness
Just the
list
memo is
witness list
5/17?
and exhibit list will be May 8th, and the trial brief and the exhibits will be May 17th. And a scheduling order will go out.
All right, thank you.
Thank you guys. Have a wonderful weekend.
Thank
Thank
you.
Thank you.
Number 15 on the docket is the guardianship of Hannah Latour, cause number 2340033306. Good morning. How are you?
Good. Can I sit?
Yes.
Okay.
So this is a review hearing, and my understanding is that you currently have emergency guardianship in place. Is that accurate?
Yes, that is.
And did you file a petition for a full guardianship already?
I have one right here. I didn't file it yet. I just got it filled out. There's a couple things on there. I wanted to propose the full guardianship, and I also want to see about getting rid of the restraining order.
Oh, okay. Why is that?
Because I don't need it. Her mother's been doing everything that she needs to do, and Hannah's gonna be 2, and she hasn't got to talk to her or anything, and it's really hard on her.
And CPS is involved in this case, is that?
Not anymore.
Well, that's because you filed the guardianship.
Oh, okay.
But as soon as you start letting the mom have visitation, if she hasn't done all the things that they want her to do, then they're gonna.
She did all their counseling that they wanted. She did the assessment. She's doing outpatient. Every drug test that she's taken since February has been clean.
It looks like we appointed a court visitor in this case, or somebody did.
Yeah, for the father, because he's homeless and I haven't been able to find him.
Who was appointed on this? Oh, Josephine Townsend. I don't see her here today, so. Okay, so, looks like you've taken care of everything. we haven't received the CPS records yet, and we haven't heard from the court visitor, so why don't we set this over? Did you wanna file that today?
Yeah.
Okay, why don't you hand me that paperwork, we'll file that today. We're still waiting on the CPS records, and we're still waiting on a report from the court visitor, which is just to contact the father. For now, I'm not gonna lift a restraining order, I'll set this over to a date as close as possible.
Yeah, 'cause she has her birthday coming up, I really like.
What day's her birthday?
June 12th.
Okay. I'm gonna set this on for June 2nd.
Okay.
Simply, it's gonna be a quick review. This court, I will be appearing via Zoom, so if you wanna appear via Zoom too, I will not be sitting here in this court.
Okay.
Okay,
What time was that?
same time, 9 a.m.
Okay.
And then we can reach out and see what's going on with Miss Townsend. Has she reached out to you at all? No. Okay, great. All right, we'll set this over to June 2nd, and I will get this, I'll review this and get it filed for you, and then we'll go from there.
Okay, thank
All
you.
right, thank you so
Your
much.
Honor.
Yeah.
Have a great day.
You too. I'm gonna take a quick recess. Busy student. All right. Okay. All right, we are looking for, we could do Wilson and Wilson, number 3 on the docket, 1530222714. That was Miss Petrie and Mr. Boyd.
Morning, Your Honor.
Good morning. And could you state your name, sir?
Edward Wilson, Wilson.
Thank you. And are you still represented by Mr. Boyd?
Negative, Your Honor.
Okay, when did that happen?
That was last Friday, Your Honor.
Okay. Good morning, Ms. Petrie.
Good morning, Your Honor.
All right, so we are here today because father wants to expand visitation. I received information from mom that regardless of the things that the father has done and that CPS report was completed, that she still does not want the father to have visitation. Is that accurate?
Correct, well, not that she doesn't want them to have visitation, but she is requesting that it be supervised. Would Your Honor like to hear my argument?
Yes.
Okay, thank you, Your Honor. Your Honor, as you're aware, we did receive the CPS report. It came through and we were actually given a lot more information than we ever had. Based on the reports that came through and the declarations of respondents' ex-fiance and the criminal history that has come to light for the first time, we are requesting that my client's most recent proposed parenting plan be adopted, which would incorporate supervised visits. CPS, contrary to Mr. Wilson's belief and representation to the court, did make a finding, and that finding is that dad poses a moderate risk of harm to the children. With that finding, 191 factors need to be put into place, and his access and time with the children should be minimal at most. My client would prefer that supervised visits continue, but she understands that the court may disagree. We therefore came up with a reasonable parenting plan that would adequately protect the children. The threat towards my client that sparked this action back in September, Your Honor, was not the first time in 2022, nor was it the second time in 2022. There was a second time. He made a terrorist threat against my client in June, which we did not know about. And then there was a threat back in 2015. So this is the third time that he has threatened to kill my client. And the most recent one, which was the one that sparked this action, he had a plan. We are requesting that the restraining order protecting my client remain in full force and effect for 5 years. And I would like the court to note, if it has any doubts about this, that in February of 2022, the children themselves called the police for assistance while at Dad's house. That's pretty telling.
When was that again? I'm sorry.
That was in February of 2022.
Okay. And what was the reason of the call?
The kids felt unsafe. They were scared.
Why?
And they called the police to protect them from Dad.
Yeah, can you tell me what was occurring that made them feel that way?
I don't know.
Oh.
The report did not expand on that.
Okay, thank you. Continue.
Finally, one must ask, where is his spouse in all of this? We are also concerned that his spouse does have firearms. She's not subjected to the restraining order. Those firearms may be accessible to him, so we have some concerns about that and are asking the court to take some kind of safety precaution on that. My client is requesting specific dates of June 22nd to 26th for a family trip. She wants to make sure that she has those specifically designated. And the court needs to be brought to, this needs to be brought to the court's attention as well. The last time we were here, the court ordered that overnight visits were to begin again. For the first time in 8 months. As soon as those started up again, Barrett started wetting his bed. So, and he hadn't been wetting his bed for the past 6 to 8 months. So the minute these overnights started, the bedwetting started. This is a clear-cut sign that something's wrong, and precautions need to be taken to protect these children. Submitted.
So, Ms. Petrie, then what's your plan? You said that you had a plan.
Yes, we submitted a proposed parenting plan that is actually quite detailed and provides him with supervised visits. And we're requesting that that be adopted.
I haven't received that, Your Honor.
You haven't received it, Mr. Wilson?
No, or the declaration that they're mentioning from an ex-fiance. I haven't received that either.
Ms. Petrie, did you want to address that?
My understanding is they were sent to his attorney before he withdrew.
Oh, okay. So maybe that's why you didn't get that.
Perhaps. He also failed to forward a dental bill for over a month.
Your attorney?
Correct.
Okay.
Yeah, Your Honor, he was, the proposed parenting plan was filed on May 2nd with a certificate of service for May 3rd.
Well, that would have been cutting it close for him, right?
So if he wants a continuance to be able to respond to those documents, we're fine with that.
What do we have happening for overnight visits right now?
Right now, you ordered him to have Saturday overnights every other week.
Okay.
Every weekend, Your Honor.
Huh?
Every weekend, Your Honor.
Every weekend. Well, I'm kind of, I have some concerns right now. You can understand that, right?
Understandably.
Tell me how do you think that visit went?
The overnight visits, Your Honor, they're going very well. Barrett hasn't had any bedwetting incidences at my house. He said that he had some at home, but that his mother blamed them on his sugar intake.
Okay. And so when's the next overnight visit, Ms. Petrie? It's this Saturday then?
It's supposed to be this Saturday, yes.
Yeah. And what is your plan with the children, Mr. Wilson, for this Saturday?
Well, I have my parents in town visiting here, and my wife, of course, is back at the house. She is beside me in all of this. Play outside, feed the birds, run the dog.
So your parents will be staying in your home with you?
Correct, Your Honor.
Okay. All right,
And
go ahead.
my wife does not keep her firearm in the house. It is at her ex-husband's house. We have no firearms in the house in accordance with the...
So you haven't had an opportunity to read all the stuff that was filed, and it's significantly disturbing, I will say. And it's pretty objective. So that's kind of tough too.
Seems to be from a person of ill faith, though. someone that I had to
You mean
remove
because of
from
your
my life.
you mean your declaration of you mean the declaration from your ex?
If that's what
That's
you're
not the
referring to.
only thing I'm addressing here.
Okay.
That you saw, once we received all the reports and stuff, this is not a one-time thing as we were as I was informed in the beginning.
Correct, Your Honor. The petitioner does call CPS at any opportunity, but they presented this as if it was an actual allegation of abuse and there would be negative findings, and in the CPS records, it shows that this was a risk-only assessment. There were no allegations of abuse and there's certainly no negative findings.
Right. I'm concerned about a lot of things in here regardless of whether there's abuse or not. I'm concerned about the feeling of unsafe, the children not feeling safe. I'm definitely concerned about their mother not feeling safe. And what I was told, this was a one-time incident where there was like this homicidal ideation of mom, and it doesn't appear that there was a one-time thing.
That's also not true, Your Honor. I specifically told my counselor that while I do not fantasize about harming her, I do fantasize about a world in which she does not exist.
Okay.
And those are very different things.
Okay.
I need no threats to
Because your
harm me.
parents are in town this weekend, I'm gonna allow the Saturday visit. And then I'm not gonna allow any more overnights until we rehear this case, cause I want to get my eyes on it. I'm very concerned, about things, and you're gonna have an opportunity to review all of the information that's being raised, and so I want you to have a really good opportunity to address, the issues that are being raised. I don't feel like you have all the information in front of you, and that's not fair to you.
Correct, Your Honor.
So, we're gonna set this over. My next available date is June 16th. Until that time, we're not gonna do overnight visits, but you can have 8 hours on Saturday.
Should I just draft, do you wanna just do an NCR order, Your Honor? Or
I
should just send something
I
in?
know that makes me sound lazy, Miss Petrie, but I don't want to because I've got a lot going on.
That's okay, I just thought I'd throw it out there.
Yeah, I know, it's a good one. I wish that you were here, because then you could fill one out for me, but, if you could just send me something, I'll get it signed by, today, just something.
Yeah, we'll send it over.
Yeah. And then, I'll get that signed and we'll get that in. Next court date, 6/16 at 9 a.m. And then you'll have an opportunity to review all that stuff and stop by Mr. Boyd's office and see if you can pick up the stuff that was served there. Okay?
Understood, Your Honor.
All right,
And that was in the morning on June 16th, you said?
9 a.m.
Okay.
Friday, it's the same thing like this, a docket.
Thank
All
you,
right.
Your Honor.
All right, Miss Petrie, I'll sign that order when you get it emailed over to me, okay?
Okay, thank you, Your Honor.
Thank you, have a good morning. All right. Thank you, Mr. Wilson.
Thank you.
All right, is Ms. Hawk here yet? Nope. We'll go on to the Frankie matter, cause number, it's number 8 on our docket, cause number 23-007-0106. Look at that. Are you hearing Frankie?
Yes.
Oh, cool. I just called the case.
Oh, you did?
Yeah.
Great timing.
Yeah, it's perfect timing. Good morning, Mr. Roberts.
Good morning, Your Honor. How are you?
Good, thank you. Good morning, Mr. Frankie. And I don't see Miss Frankie. Is she planning on being here, Mr. Roberts?
I do not have any information to provide at this time.
Okay. My understanding is that the petitioner, petitioner dad wants to set a visitation schedule that can be, is just consistent. That if mom can follow that, that schedule, I think, what was it, 3 months in a row or 3 weeks in a row? That's right.
Sorry, that was, yeah, something like 3 months. After, if 3 months, if they work through the same,
Yeah.
that would become the plan.
Yeah. And, so, Mr. Roberts, what's your take on this?
So, we're still in this limbo situation. My client, as far as I understand it, doesn't have a permanent residence since moving out of the home. So, the thoughts that I have about what Mr. Frankie said, as my client is not here to speak that directly, I think the initial stage, I don't really have a comment on that. On page 2, line 21, where the proposed parenting plan, the next stage, is basically, page 2, line 5, that next plan is a 2.5-year plan with somewhat limited time. And I think if my client can get stable and do the things that the court is expecting, that first stage should not exist for 2.5 years, but that we can get to the local rule plan in less than that time. So the stretch of what's been proposed, I think, is excessive, but I understand the court talked about a tiered up system, a tiered up plan, and I can't really say anything. It's not this, what's been proposed isn't wildly inconsistent with that.
Right.
The timeline is the issue, and how there's another plan in 2027 that starts 4.5 years from now, or 4 years and change. In that plan, Section A indicates that JD will have discretion on dates and times if a consistent time hasn't been established. I understand there might be a problem if there hasn't been a consistent time established in 4 years, but Mr. Dixon made clear that giving JD the discretion was problematic, and that should be avoided. And so I object to that being in this section. Additionally,
okay, so
Sorry.
I'm sorry, Mr. Roberts, I'm not trying to interrupt you, so
No,
please
it's
make
fine.
sure you get your argument in. But so you're saying it's like you think 2 years is too long, and you also don't think that it should be at the discretion of the child, because that's not a good idea.
well, I think Mr. Dixon mentioned that
I
any
agree.
discretion of the
I agree. I
child's
just want-
language
I was
should be
just
out. So
summarizing.
yes,
Yeah. Okay.
sure.
So then, so instead of 2 years, how much time would you want?
I mean, I think when she has a stable situation, they can have consistency.
I think what's
I
happening
think
with
that
this though is that Miss Frankie, like if we were so vague like that and ambiguous, what happens is then it leaves everybody else kind of in a state of feeling like things aren't complete. So she continues to not meet any of the benchmarks, and not that there's a lot of things that she had to do, but she doesn't seem to be getting it together, to put it as kindly as possible. And I'm sure that's got to cause their son a lot of stress, because he needs something concrete right now. And I agree, he should not have discretion. I sat down and talked to him. That would be awful for him to think that he was the one making those decisions. But I would agree with everything else at this point. I think we could put something in about Miss Frankie having the ability to come before the court if she shows a significant level of stability prior to the 2 years. Does that sound okay, Mr. Roberts?
One of my concerns was if this is locked in place and there's a high burden for her to meet the inadequate cause showing.
I'm not.
I think if she can show she's met.
Yeah, that's why I'm saying let's say
Right.
she can bring it to the court without adequate cause once she's shown a significant degree of
Correct.
stability.
And I think you are addressing concerns that I'm looking at.
Yeah.
So, I don't want to nitpick the timelines here.
Yeah.
That was what I had flagged to discuss, and I don't want to belabor the point with you. So if she can bring it back when she's met those markers, I don't have anything more to comment on that.
Let's have her be able to bring that back. And so can we talk about the hair follicle test, why we're asking for that again, or the nail test?
Because that's what you said that you wanted her to do.
Oh, okay.
That's why I put it in there.
Oh, okay, I
You
got
said
it.
it wasn't going to be a hair test, it was gonna be a nail
Yeah,
test
but
because of the
remember
hair
she's,
dye.
yeah. Okay,
And Your Honor, on that point, because I know there was a lot of back and forth, when the court mentioned at one point you wanted the nail test instead of the hair test because she could bleach her hair, but the hair test did show positive for cannabis. So it's not that she bleached any substance out of her hair, that she did have cannabis showing, and that was given to Mr. Dixon. So, I mean, I would object to that, but I know the court's had this case history, but she did provide a test with hair that was.
that's interesting. I didn't think about that like that, Mr. Roberts. That makes
And
sense.
I think nail and hair tests are equally
I agree with
costly and
you.
equally accurate,
Yeah,
so.
if it
but,
showed her cannabis use, then you're right. I agree with you. You're right. Thank you for
But
bringing
then
it
again,
up.
if she has no cannabis use when she does this again, then it begs the argument may be that it begs the question, I want her to get the test that that no one's gonna be able to question. I don't think that I've never heard of bleaching the cannabis out of your hair or anything, but, I haven't researched that diligently, but I know
you can definitely
that
do
she
that.
had lighter. Okay, I'm in a position to dispute that.
All right. So
Anyway,
I don't think, Mr. Frankie, you're not feeling that, we did get a drug test result that was given to Mr. Dixon, and it did show positive for cannabis. Do we still need to do you think we still need to do another drug test?
Would that?
That's totally irrelevant. Oh.
Pardon?
Was that for me or Mar?
I was asking you, but,
Oh,
how do you
yeah,
feel?
I just think it's irrelevant at this point, Your Honor. There's other things, but that's
Yeah.
irrelevant, I think,
Yeah.
at this point.
Okay, so we can remove the drug testing portion. If for some reason something arises where we think that we need another drug test, someone can bring that in front of the court. I know before we saw some pretty erratic behavior. That was one of the things that we were concerned about. Except for the clause where we're adding in that she can bring it forth if she shows a significant level of stability. No need for adequate cause. I think we can accept the parenting plan as proposed.
I have a couple questions, if the court's ready.
Yes, I am.
With respect to JD's discretion, there was the visitation time discretion and the safety discretion that he can basically leave the visit at any time. My understanding is that the court is not giving him discretion either of those, correct? If Mr. Frankie has an issue, that can be one, but is that correct, Your Honor?
That is, well, I don't, so what do you, Mr. Roberts, I mean, you've read through the information we had. How do you feel about him not being able to stop a visit when he doesn't feel safe? I mean, that seems concerning. I think any child in any case should be able to stop a visit when they don't feel safe. But in this case,
I understand that.
and in this case specifically, it's not giving him the discretion. I don't know that it necessarily has to be in there, but I do think that it's important. I mean, just the thing when he wouldn't get in the car because of the 5 dogs, I don't think that's unreasonable. I mean, it's just something that Miss Frankie continues to do. She knows how anxious she's making him, and she still continues to display behavior and have people around her or these animals when it creates a very chaotic environment for him. So I don't know that we have to have it in the thing. I hope he knows he should always be able to say, I want to go home when she's not feeling safe.
I agree with you, and it's always tricky with the parenting plans issues if a child's not going to be safe, but if a child doesn't go, then it becomes an issue between the parents of, he said he wasn't safe, no he didn't, and then it's an issue for contempt. And I'm not saying that Mr. Frankie would be in contempt if JD didn't want to go, but then it becomes a question of, well, he didn't want to go, he's not going to be held in contempt because there was no bad faith, there's a legitimate defense to the child not going, but having it built into the parenting plan is something that I think is putting the cart before the horse. And if JD legitimately doesn't want to go, Amy's motion for contempt is going to be wildly unsuccessful if the child talks to you or there's obvious evidence that he felt unsafe.
Okay,
But
agree.
having it in the parenting plan is my
I
objection.
agree with you, Mr. Roberts. Take that part out.
Okay.
So here's what it says.
Last.
I'm just
Hold on.
gonna
Go
have
ahead.
to tweak
Yeah.
this language a little bit. So we said if any time JD is placed in an unsafe, unsanitary environment or is not comfortable, he can make the decision not to leave with Amy. So I think what maybe we could say is that.
I think we should just say Amy is to provide a safe and sanitary environment.
Which Mr. Roberts is saying, that goes without saying.
Well,
right?
it obviously doesn't go without saying in this
Okay.
case.
Okay.
No, I think Your Honor's suggestion is correct. She has an obligation to provide an adequate environment. It's not JD's decision to have the parenting plan give him the authority to say that's not sanitary
Yeah.
enough. It's an obligation she has.
Yeah, I think that can be in there. Okay, what's your next thing, Mr. Roberts?
Only section E, text messages. I didn't know if it was just a typo or if I misunderstood. The section says text messages, but it said all correspondence should be via email. I want to make sure that text messages, we're clear on what Mr. Frankie is proposing and what correspondence is acceptable.
He's asking that the correspondence between the parents be through email.
Okay, so email
Okay.
works, except for what, in emergent situations, it's gonna have to be text message.
Except for an emergency.
Section said text messages, so I didn't know if specifically, I have
It's
no
email, he
problem
said,
with
so the
email.
section, it's communication, so it's all communication, so it should say communication, and then communication should be via email unless it's emergent, and then it can be via text message.
Okay, and if they're, okay.
Is that it, Mr.
And I
Roberts?
can, those are the issues that I had, correct?
Thank you so much. All right, well, Mr. Ball, will you send out a copy of that to everybody, and we can get that signed off on?
I will.
All right, do you want me to set a presentation day?
Well, we have a court date coming up here, but
Oh.
yeah, we can have a presentation.
No.
There's a child support date on the 6th. I think we can get this worked out. I think Mr. Ball is clear on what we're doing, but we can do it however you want, Your Honor.
Well, what's the date that we have forward?
I think it's 2 Fridays.
It's the 6th, I believe,
I think it's
or the 9th.
January,
It was
June.
Friday.
Sorry. I think it's June.
If it's a Friday,
Yeah, it's
June.
the 9th, June 9th.
All right, so that will be the date if we have to use it.
Okay, yeah, it is.
Okay.
All right, great, you guys have a great weekend. Thank you.
You too, Your Honor. Thank you very much.
And we are ready on the, let me just really quickly recall the, for 13 and 14, the Hickman matter. And, I have Zane's father's here, and it appears that he is giving us our consent form at this time.
I didn't know a case number to put on there.
Pardon?
I didn't know a case number to put on there.
Oh, that's fine, thank you, sir. And I've already, under oath, you've already indicated that you are consenting, and then is yours. Where's she? Miranda, are you here still, or did you have to take off? Looks like she might have took off, okay. Oh, no, there she is. All right, okay. So, regarding Zane, we have a consent form, and have you seen your daughter?
No, so I got a phone call, I think it was like 2 weeks ago, I got a phone call from the police, stating that somebody had called and wanted to do a welfare check on my daughter. They went to the apartment, nobody was there. I got a text message from somebody that knows my daughter since high school saying that her boyfriend said he hadn't seen my daughter in 2 days. So the police asked me at that time if I wanted to file a missing persons report. I said that I did. After I got off work the next evening, I went over to her house. The door was open. I went in there. I said some choice words to her boyfriend, and then followed my daughter into her bedroom, sat and talked to her for about 15 minutes. She got up and went to the bathroom, and I left. She was visibly on something. She was talking a lot of stuff that had nothing to do with anything. She was
Yeah.
bringing up my ex-husband that is dead.
Yeah.
Had nothing that had to do with
So
her children.
you've seen her, and so she's still in active use, and she's not in a good state.
Well, and after I saw her, the police contacted me the next day, and they asked me if I had any contact with my daughter. I said, yes, I did. And so they went over and talked to my daughter. The police officer called me back and told me that she's had very little interest in either one of the children.
Yeah, I understand. So I'm just, well, the reason why I'm asking is this consent form we just had Dad sign. Is there any way you could get Mom to sign that?
I have she lost her apartment, and I have no idea where she's at.
Okay.
Like literally no
All right.
clue. The only thing that I can think of is you can possibly give it to me, and she might be at her boyfriend's mom's house with him, but
well, I don't need it. I mean, I do need it. You need it. That's why I'm asking for you to do this if you want to do it. And then asking the same from you, Miranda. It sounds like she's not really interested in parenting at this time, rightfully so, since she's in active use. And so, if possible, if you guys, you can find this form. I just got this printed off the Washington Court forms. It's just under the guardianships, and it says parents consent to minor guardianship. So if you guys could get that signed off on, both of them, that we can get this case done a lot faster. That's all
Okay.
I'm saying, instead of us having to go through an evidentiary hearing and everything.
And I also wanted to bring up that At the same time I did the missing persons report on my daughter, I also filed a child abuse charge against her boyfriend, Patrick McDonald.
Yeah.
Because my grandson told me several instances of where he was abused by him.
Yes, you did mention that inside the, you'd mentioned the thing about the abuse,
So I just wanted to bring that up.
Okay, well, for now, what we're gonna do is we're gonna set this over, I'm gonna set it over to June 23rd. I'll do an order extending your emergency guardianship on both children, because we don't have another guardianship right now.
Okay.
I have to extend it on both children.
Okay.
And Miranda's gonna get to me the ex parte order for guardianship. Once you do that, I'll appoint a court visitor, I'll appoint one, to that case, to Vanna's case. And then, so take care of the things you need to take care of. Do your order for CPS, which apparently they're doing it differently now. You can do it online. I saw something in your case on that, but you probably don't know anything about it.
I don't.
Yeah, don't worry about it. But, and then get me your bankruptcy-ish things, do the lay training. It's all really easy stuff. It seems overwhelming, but each thing takes about 3 minutes, right? So get all that done and get that turned in, and get that emergent to me, and I'll get that signed off on, and we can go from there. Please try to get that consent form from Mom for both cases. It'll make everything so much easier.
Oh, I'm sure, yeah.
Okay, and I'm sure she'll sign it. Sounds like she will. I'll do the emergency, the extension later. Okay, all right, is there anything else I can do for you guys to do today?
No, and it's June 23rd at what time?
9 a.m., same thing.
9,
as this.
yeah, right here?
Yeah. Mm-hmm.
Because this morning I went to the other building
know.
where I had.
Yeah, sorry about that. It's right here in the
No,
Depot
that's
building.
fine.
Okay. All right.
Okay, well, thank you so much.
Thank you for coming in, and thank you for signing that consent, sir. That's
No
really
problem.
good for you to know what you need, your daughter needs, for your son needs for parenting. Thank you. All right, thanks, Miranda.
Bye, Miranda.
Thank you.
All right, then we had Guardianship Newsroom, that's right, it was an add-on. So you're here today. Come on up. And I don't have any paperwork with me. We had attorneys and everything on this case, right? Oh, there's Mr. Waxler.
Good morning, Your Honor.
I'm gonna go ahead and try to pull this case up on Liberty. I don't have anything up on, because I did not know until right when I walked out.
Readiness.
Is readiness, we wanted to, Mr. Waxler, have you had contact with your client?
I have.
And what's?
Your Honor, if I could.
Go ahead.
To this matter, we have a trial date or evidentiary hearing, May 24th. Today is the readiness hearing. We're asking that the court consider setting over the evidentiary hearing on the 24th of May. I do have a vacation with my grandchildren visiting, and also taking a little bit more time will give us the opportunity to potentially settle this case. So we'd ask that the court consider setting it over approximately 45, 60 days, something of that nature.
And your client, Miss Bailey, she's not here, correct?
No, she is not. She couldn't get away from work today, Your Honor. We also have a guardian ad litem, Tina Day, who Tina is here, so
Yeah,
good
she's
morning,
here, I
Tina.
see her here. Yeah.
Good
Okay.
morning, I'm here.
And so you're asking me to extend the minor guardianship at this time and set a new trial date?
That's correct, Your Honor.
Okay. And, sorry. Are you comfortable with that? I know you probably want this thing to get finished.
I'm frustrated. School's ending and am I re-registering him? There's sports programs, summer camps, like I have to enroll him in all these things, and if my sister plans on getting her act together and getting her son back, great, then I'm not gonna go out and do all of these things.
Yeah, you're gonna do these things.
I'm
telling you right now that you're gonna need to do these
Nothing's
things.
changed.
I know, nothing's changed.
So
I'm not gonna have Mr. Waxler miss his vacation. We work him to
but
death.
60 days seems excessive, right?
Well, it's, so there's a couple ways to look at this. It could be seem excessive to you but honestly, we're just in the same state. What we're gonna end up probably doing is flipping this emergency guardianship into a full guardianship. So it really doesn't change anything for you except for you're making these appearances. That's why I'm telling you, you should start coming in via Zoom. But it's the same thing. So it's 60 days until the court makes that final decision, which is what we're which apparently is gonna be what we're doing now. She's not doing anything she's supposed to do.
She went back to work.
Yeah. That's good.
Mhm.
Yeah. But So 60 days, I think, would be good for you to just not have to think about this. Like, I think you should try to go through summer now, because you're not, so you don't have to worry about it through the summer. So we could put something, a date like in September. I'll extend the emergency guardianship over till that time, because you've already filed the full, and that way you'll have your summer and have everything set for that time.
Okay, so that answers my question about summer camps. What about
Yeah.
re-enrollment in school?
You're gonna need to enroll them in school too.
Okay.
Okay? Sorry, I mean, I know this is frustrating, but you're doing everything you're supposed to do. I hate that you have to keep coming back here, but
Me too.
you took this responsibility on because you're an angel, and you're gonna have to just keep doing it because nothing's
here.
changing.
Since we're talking, can I ask you a question?
Yes.
And I apologize, it's kind of an ignorant question, but I don't know what
There
I'm
are
doing
no ignorant
here.
questions.
Witness list, I'm listening to you and
Yeah.
taking notes. Witness list, exhibit list, trial brief. I don't know what any of that is.
Yeah, yeah. So we're not having to worry about that right now anyways, but like, let's say you were calling your mom to testify that, like, your sister hasn't gotten it together, stuff like that. Like, those would be your witnesses, so you'd make a list of the people
And am
that.
I questioning my witnesses?
You would be, but I usually do most of the questioning anyways. It's a very brief, these things don't have to be full-blown
It's not super
trials.
formal, like.
This will not be a super formal
Okay.
thing when we have it, and I believe Mr. Waxler will probably make a proposal prior to then that we won't have to go to trial.
That would be wonderful.
Yeah, he's got to get some time to get that going. Ms. Day's already given a report that's, makes pretty clear what needs to happen in this case, so.
Okay.
All right, so
I
then.
won't worry about that for
Yeah.
now.
The other thing I want to say then about that, so we'll go out to September, and have you asked for child support yet?
I haven't, and I did wanna bring that up. She is working.
Yeah, so you need to, so right now, you need to probably just do a petition for child support in this case.
Okay, do I file that with the state?
Are you getting any TANF or anything for the child?
No, and Miss Day told me I should have applied. I just keep thinking, is something gonna change? And
Yeah.
not wanting to go through that whole process.
Maybe you could talk a little bit to Miss Day, then she can help you to tell you what the next steps would be in that, but you should definitely be getting child support if she's working.
Okay. Is that TANF and child support, are those different?
No, TANF is like when the state steps in to give you like food stamps for the child, or medical care can be done, and once that happens, the state kind of gets involved and they'll do your child support stuff for you.
So probably just filing for TANF will take care of the other?
Yes, yeah.
Okay. Okay.
Okay?
Miss,
go ahead.
If you contact me, I'll help you with that process a little bit. It's a little bit different than just straight TANF, but it's not very complicated. It can be done online.
Perfect. Thank you, Ms. Day.
Thank you, Ms. Day. Thank you, Mr. Waxler. So I'm gonna have Jen send out trial dates. We have everyone's email addresses, I assume. And so you guys can choose the trial dates. We'll do it sometime in uh-oh.
They're in the chat.
Oh, I didn't see. I don't have my thing up, sorry. They're in the chat. Okay. So we have September 6th or September 13th?
Well, Your Honor, I know the 6th is not available for me.
I can do the 13th. I also am not able to do the 6th.
I don't want to do the 6th either.
It's my birthday, Your Honor. We have plans.
Okay, so September 13th?
Let me confirm that with my schedule, please. The 13th will work.
Awesome, thank you. That'll be our trial, we'll have readiness then on. Let's do readiness on the 25th of August. Let me look at my dates. Yeah.
Your Honor, may I be excused from readiness? I am not back until the 1st
Yes.
of September
We'll
from
send you out
vacation,
this-
but
Yeah.
Yeah, I'm ready, so whenever we go is when we go.
Thank you so much, Miss Day. All right, guys.
One final thing, Your Honor, will the 13th, the evidentiary hearing, it's currently set at 1:30 for half day. Would that also be 1:30 on September 13th?
Yes, thank you for asking.
Can I ask?
Very
if,
good.
Ms. Day, has anything changed from your last initial report?
The only update I would offer to the court is I've had no contact with mother, so no, nothing from my report has changed. My recommendation stands that the child should remain with the petitioner.
Yep, okay, thank you so much.
Thank you, Your Honor.
8:25
Have a
at
good
9
weekend.
a.m.?
9 a.m. You just need to, this is your new norm now. And it sounds
I
like it's,
just never expected it to go this far.
I know, well,
Here we are.
you're doing a great job.
Thank you.
Yeah, okay, I'll see you guys, in August, except for Miss Day, who's gonna be doing something super fun, it sounds like, alright. Alright, thank you,
Your Honor.
have a good weekend.
Trial's 1:30?
1:30,
1:30.
Yeah.
Thank you.
I'm gonna do it with my pen. Alright, Ms. Hawk. Number 2 on the docket is the Olvera matter, 15-302-1319. Ms. Petrie. So we're here on a motion to vacate the judgment, and then also Ms. Petrie filed a motion for disqualification. There was a declaration by her client just indicating that it wasn't not necessarily that she was trying to disqualify me because of the start of a new action, which I have to say really quickly going backwards, and you weren't here, Ms. Petrie, is I did read your case law. Finally, must have not had it on disqualification regarding the modification, and I would agree that maybe that you wouldn't even have the ability to do that either. So I just wanted to say that. I do not think that I can not be fair, and that I will be, that I cannot be impartial. I did go back and try to review the hearings of me swearing at her. I did not find those at all. So I was kind of confused by that being mentioned in there. She said a lot of other things that I guess this court needs to really take into consideration, because I want to make sure that she feels like she's being treated fairly. I do feel like I've been very fair in this case. In fact, I have not held any contempts where some may have been held. I keep trying to give opportunities for her to follow through with the things that she said that she would do, and give her an opportunity to show the person that she says she is, and not just by her words but by her actions. I do not think it would be fair to either party, nor the children, for me to disqualify myself at this point in the case. I think that I said this in my last hearing. I know it because I had to read it before I watch it before I came in today, because I wanted to make sure to address any of those issues that she raised. That it wouldn't be fair. I've got to. I think that the reason why she wants me off the case is because she now wants a different decision, and that's not fair. So, in that case, I did again. Like I have found that I can be a little emotional or like and aggressive sometimes in my when I address people, and it's something that I'm hoping that I get better at. But I went back and watched, and it wasn't the case in this case, which made me very happy. So I don't know exactly what your client's referring to when she said the things that she said. I don't know if she's here with us and would like to address that issue.
I prefer that my client, I'm going to be doing the speaking for my client today, Your Honor.
That makes sense. All right, Ms. Petrie, you go for it.
Well, it is Ms. Hawk's motion to
I wanted
vacate.
to address your, I'm sorry for interrupting. I wanted to address your disqualification request first.
Okay. My issue is this, Your Honor. I watched the trial this week. I just saw it a couple days ago. So, and I took copious notes. The one thing Your Honor did do is you told her over and over and over again that if she did not agree to the guardian, that you were going to give sole decision making with a parent coordinator to dad.
Yeah.
Okay. That's an inappropriate, I'm sorry, Your Honor, with all due respect. That's
okay. You
can't take all decision making power away from the primary parent.
Oh.
It doesn't make sense.
But I swear,
but Your Honor, that is exactly what you threatened to do.
Yeah, no, I agree with you. I disagree.
You said you were going to take mom completely out of the picture.
I agree with you. I said those exact words. Yes, I meant them.
Yes,
I meant them.
And Your Honor, that's not okay.
That was what the trial was about. The trial was about me deciding who should be the decision maker, and so that is my job. That was one of the things that this court had to address. And so I was trying to give her an option. I was trying to give an option for her not to have it be like that, because it wasn't working the other way. So one of the decisions the court had to make at that trial was to decide who was going to be making the decisions, if parents were going to be making them jointly, or if one party was going to be making them. And what I decided to do, so that I didn't have a huge impact on your client was to offer this alternative that I actually wasn't the one that raised, where the experts raised in the trial. And so I decided we'd do it this other way. And I said to her, if this doesn't work, my only other option is to go back to having Dad be the person. And so
But that's
that
not your only
was
option,
my
Your Honor.
responsibility. That was my responsibility for the trial, to make the
But
decision.
that's not your only other option.
Well, it is, because
Other options.
the other option was to have it go the other way, which wasn't working, Ms. Petrie.
But we didn't even give it, they didn't even give it a chance. They
They-
hadn't
they-
even
they
had
had-
the guardian.
They had
Your Honor,
given.
hold on, let me,
Okay, go ahead,
let me
sorry.
just say one thing.
Yeah.
I did watch it, and this was something that was discussed, and I think Your Honor is right. There does need to be a third party present to help these parties make decisions. I get that, and I agree with you completely, which is why I'm contesting the CR 60 motion. But the thing is, telling my client that she has to agree or lose all power, and those are her only choices, because there are other choices. There still are other choices. But putting her in that position where you either agree or you lose everything.
Right. I do that with other parents. I say you can't use drugs, or if you do use drugs, you won't have parenting. It's this thing I have to do. It's like this decision-making
Oh, but that's
thing.
you're comparing apples to oranges, Your Honor.
No, it's actually not, because in this case she was
not drugs.
She was preventing the other parent from getting any information at all times. And she was the decision maker.
I'm not suggesting that.
So give me a second though. The trial, Ms. Petrie, was regarding was the decision maker, and she was to include father, and she did not, and she had all these reasons why she wouldn't. So I had to take that away if she couldn't do it that way. That wasn't going to work anymore, so I had to make another decision. So it was to make father the decision maker, which I didn't want to do to her because she had been taking care of the children and doing this great job. So the expert said, let's use a guardian. I said, okay, I'll try it this way. And if this way doesn't work, then we're going to father. That is an absolutely appropriate way to handle that. I still believe so. You can appeal me on that one issue. If you're saying that she was under duress because of that, then what you are saying to other parents is, I'm saying marijuana is legal. You're not to smoke marijuana while you parent this child. It is legal, but you're not allowed to smoke marijuana if you smoke marijuana while parenting this child. You no longer get to parent anymore. I am telling them they cannot do something that is legal under duress, because I am telling them I'm going to take away their parenting time. In this case, if that you consider that duress, you're right. Your client was under duress, and I stand by that decision. So that's what I'm saying. I don't think that she was under duress. I do understand what you're saying. I was trying to make it very clear. Here is your path forward, and if she didn't want to choose that path, I understand. That makes sense to me. But the other side. This was the other side. I was saying, from what was being offered to me, I choose this, unless we can do this. And unfortunately, that's my job.
Respectfully, I disagree that you can compare medical decision-making to drug use.
I understand.
I don't think that I don't think they're the same at all.
I agree. It may be an extreme example in some sense, but had you, and I'm sure you said you watched the entire trial, had you seen the entire trial, you could realize that there was no way around this, and that the father had been consistently being pushed out. And so, to me, in fact, what I'm talking about is way worse. This thing that was happening to the father and his ability to parent his children was way worse than someone smoking marijuana.
And see, Your Honor, this is where I'm having the issue. You're having so much sympathy for father because he was pushed out historically, but the reason he was pushed out historically was of his own doing. He created the conflict.
Okay.
He created the situations denying this child services the child wanted. He's the obstructionist, not my client.
Okay.
That shows a bias towards him, Your Honor.
Oh, okay.
That's exactly what Dr. Baxter's report said. Wasn't actually happening whatsoever.
So, I mean, Ms. Petrie, it's hard for me is that you said you watched the whole trial, and that meant you watched all these experts that talked about these issues, and so you're saying, I just went with what the experts said, and they did a very good job of handling it, and so now you're just telling me I'm wrong for following, that I'm biased because I followed the experts' recommendations. So I'm having a hard time with that, but I understand your position and your argument, and I appreciate it, and I accept your disagreement. And so I don't have a bias. I did try to use what the experts say to help me make my decision. We did spend a ton of time doing something very creative wrapped around this, with in many ways very costly, so it's unfortunate now that that's being described as bias, that I followed the experts' recommendations in this case. But I understand it doesn't make your client happy. So do we want to argue then? So I'm denying the disqualification. Did you want to do some type of thing where it goes up to the Court of Appeals and we stay what we're doing now until that time?
Well, a lot's going to depend on how you decide on the CR60 motion. Your
Well, so one of the things that you said to me just now, Ms. Petrie, is that you thought that this third party thing was a good idea. Do you want more time to discuss that with your client before I address the CR60?
No, I don't think there's anything wrong with the orders as they are, and I don't think that they should be vacated.
Oh, but she's not doing the guardianship. So you're saying that you think that there should be this third party, but she's saying no to the third party.
She's saying no to this. She's saying no to the cost, Your Honor, not the third party. She's willing to work with a third party. She's willing to do and follow the orders if it's economically feasible.
Okay, well, that was not an argument that's been raised once.
Well, actually, Your Honor, it was throughout the trial. Mr. Blum constantly expressed concerns about bringing in a third expert and the cost concerns to my client. Mr. Blum argued that over and over and over again.
That's exactly why she said she fired Mr. Blum, so she could pay the cost of the guardian, which she then told that she was only signing the papers under duress, meaning no certified professional guardian will touch this case. And then she hires not one, but 2 more attorneys. She hired Mr. Robinson on a Friday. He withdrew on a Monday.
I don't think it's
and now Ms. Petrie magically hired another attorney. So we've had 3 attorneys on this case in 2
based on the
months.
number of attorneys they've had representing them.
What? I'm sorry. What was that, Ms. Petrie?
I don't think it's appropriate to try to impeach a client's credibility based on the number of attorneys they've had.
I don't think this was about. I think it's about financial ability.
This is financial ability, and my client and Mr. Blum expressed concerns throughout the trial.
All right. So
and in many cases suggested just increasing the parent coordinator's role, and that's what my client would like to do. Right. He's already on the case. He knows the case. He's familiar with the parties. He knows how to work with them. I
felt like we heard from him.
The
information we got was he was not able to get it done.
Yeah.
Because
able to fill this role.
Yeah, he was not able to fill this role anymore because there was no movement. Like you don't.
He's still acting as a parenting coordinator.
All right.
He's okay. I will respond to whatever the court wants me to respond to. There's a lot to respond to.
Yeah. Go ahead.
Dr. Johnson is not responding quickly to the client's needs because I think his assumption is that this is it's eventually going to get passed off into a different decision-making rubric that will make it so he's no longer needed. That's what he expressed to me, is that he didn't see his involvement in this case as being much longer term.
Right.
So that's where I stand with that. We're asking the court to grant the CR60 motion. I think the relief is completely appropriate. The language in the final orders was very clear. It's if either parent frustrates or withdraws consent for the minor guardianship, then this matter would be essentially reopened. Ms. Olvera was represented by counsel all the way through trial. She was represented by counsel at the entry of final orders. She was represented by counsel when she signed the consent to the guardianship. And then all of a sudden flips the script, says she signed under duress, doesn't agree with it going forward. So essentially eviscerates all meaning, force, and effect of the final orders that we worked so hard to accomplish by, it was kind of some parts were entered by agreement, some parts were entered by the court indicating, hey, I'm going to do this unless you want to do something different, which is exactly what we did. We addressed that at the outset of trial, that's how we were going to operate trial, because otherwise, if we went down the road of this being a knockdown, drag-out blood fest, which is exactly what it was going to be, it wasn't gonna be helpful, and it wasn't gonna be helpful for Giovanni. It wasn't gonna be helpful for Donovan, it wasn't gonna be helpful for Keelan, it wasn't gonna be helpful for any of these kids, and it wasn't gonna be helpful for the parents, because it was gonna get everyone's hackles up and make everyone even more defensive than they already are. So, that's why we're here. The final orders mean nothing now, because the framework we put together has crumbled. Ms. Olvera is responsible for that entirely. Under CR 60, that is misrepresentation. It absolutely qualifies for that. It is misconduct. She was represented by counsel throughout this. She was advised of all of this. And now, you know, she's doing exactly what she's done multiple times in this case, which is blaming past actions on a previous attorney. She's doing this now, saying she wasn't advised, she didn't know, she was represented by Mr. Blum, who I think we all think the world
Objection,
of.
mistakes the evidence. I know that there's nothing in that says that she was not properly represented or that she's blaming anything on Mr.
Well,
Blum.
the argument of her saying she didn't have an understanding and she needed someone just to explain it to her, which was her argument, Ms. Petrie, when she came in here and refused to sign, is saying just that. She had a competent attorney that went through all of this with her. So that is saying that. And so so Ms. Petrie, what I want to offer you is an opportunity to wait for me to hold off on my decision on this. If we outlined what was going to happen ahead of time. I know you're stepping into this, and I really appreciate the work you did on it, going through and watching the trial. And maybe you'll have an opportunity to go back and watch some of the hearings as well, because we had several hearings and several days that we met on this, and it's funny to me, this bias issue that you raised, because there are many times where I reprimanded Mr. Olvera, like, don't talk to the kids about this, don't do. I was trying to be very fair-sided on both sides and bring these parents together. I thought that we came up with a pretty unique and brilliant way to handle this matter, and it's unfortunate that we're not going to be moving forward on this. My intention, I will say so now, is to go ahead and vacate, but I want to give you an opportunity to decide to talk to Ms. Hawk and talk to your client prior to doing that, because this is going to have us starting back over.
Exactly. So can I be heard, or do you want to continue with Ms. Hawk?
Yeah.
Okay. All right, a couple things, Your Honor. A CR 60 motion, the grounds allowed are fraud, misrepresentation, or misconduct, and it must be willful fraud. Yeah. Counsel is trying to circumvent the appeal process. The only way the appropriate method here, she violated the order. It would be an appeal or a contempt action. It shouldn't be setting aside and bringing the parties back to zero, forcing them to go through another trial, the expense of which, like you said, it's incredibly costly. Throughout trial and subsequent hearings, my client and her counsel expressed concerns about the financial strain of a third-party expert. The court moved forward regardless. I do believe that the order is correct, and my client believes that as well. That being said, there's nothing wrong with them. Setting them aside just means that this is, the past 9 months have basically been for nothing. That's not an equitable solution. The equitable solution is to maintain the orders, maybe tweak them, maybe adjust them, but you don't have to set them aside and force the parties back into another full-blown trial.
I'm so sorry. I'm very frustrated because you keep saying that I'm doing this and then I'm forcing them back into another trial. These are literally the actions of your client. Like, it was written in the order what was going to happen, and we made this decision so that she didn't have to. I mean, all of this was made for her benefit. And so, if she's decided now to back out of the decision that she made, I think that there's a lot of I don't know what other options I have, but this was the skeleton of the parenting plan that we developed. It's the absolute skeleton, and she's just taken the skeleton out of it, so we're left with nothing. So,
that's an extreme position, though, Your Honor, because she is willing to work with a third party.
Okay.
We just have to find
we're just talking in circles now, Ms. Petrie. So what I want to do is I'm not going to make a decision today. I'm going to give you an opportunity to talk to Ms. Hawk. You know the direction that I'm going if you guys can't come to an agreement. I will have you guys back here on June 16th. And at that time, I will give you my decision if you guys have not come to any agreement. And so, and you understand that. I'll read through anyway, yeah, I'll read through the decree and the parenting plan and all of the information that we had, and I'll review any hearings I need to review, but I feel fairly certain that, I'm accurately, remembering what happened and how that occurred. And I also feel that, like, this, raising this bias, it directly points to, I mean, if you go back and watch, you can see that it was on both sides what this court was doing, but because now she's not satisfied with the decision, now I have to be biased. So.
But Your Honor, if she wasn't in support of the decision, then wouldn't she be in support of this motion?
She's not in support of this motion, she just wants things to go back the way they were. So by removing the guardian.
She wants to try to work through these orders.
Yeah. Okay, well, I'm gonna give you a chance to do that with Ms. Hawk, and then if you guys get that done by the 16th, then I won't have to make my decision.
If we're not making a decision today, I know that there are several kind of lingering issues out there that, my client was hoping to have addressed in short order, because I've been basically telling him, hey, we gotta, let Judge Banfield focus on the big issue. We're not gonna inundate her with, kind of the same little things that these parties cannot figure out.
Yeah.
So I guess I just wanted to let the court know that, and unfortunately, there will be litigation in the interim to get these issues decided.
Yeah, that's unfortunate. Is there anything that can be raised today so I can just have so Ms. Petrie, I can have an idea of what's going on?
So
I wouldn't be prepared, Your Honor.
What was that, Ms. Petrie?
I wouldn't be prepared, Your Honor. I needed to set this over, and Ms. Hawk wouldn't even agree to it. So I'm here.
So I'm not saying we're gonna necessarily.
No, we can't touch any other issues today.
I'm just identifying the
There's nothing
issues.
else before the court.
Can I identify the issues?
That's all I was asking, Ms. Petrie, not that we'd address them today.
Go ahead.
Okay.
So one of the issues is that Keelan, Shane is paying child support for Keelan. He does not have access to Keelan's Skyward portal or whatever to make sure that he is still enrolled in school. His access was cut off last November. We've asked through prior counsel to have that Skyward portal access reestablished, and it hasn't been. It's our inclination that he's not enrolled in school anymore, so he shouldn't be paying support if he's not enrolled in school. The court this is a child who's 18.
I remember, yeah.
So, I mean, the court had essentially said, we're gonna evaluate this in August of 2023. I just don't want there to be this, large back due obligation that Ms. Olvera then owes to Mr. Olvera if he hasn't been enrolled in school for several months. So that's
I might be able to resolve that one. He is enrolled full time. But because he's 18, neither parent gets access to his records. The school won't release them.
The statute says if a parent is paying support, they have to have access to the records. So I guess if there's not going to be access, we'd still ask for termination.
I actually didn't, that's not, Ms. Petrie, I'm just having a hard time with that assertion that the child doesn't, if the parents, or when the child turns 18, that they don't have access to Skyward. I don't think that's the case.
Well, I don't know, Your Honor. It happened when my daughter turned 18. I got cut off from the school.
All right, well, I think that maybe we can check. I'm pretty sure that mom's not cut off from Skyward.
That happened when she turned 18, and as far as paying support, yes, he still has that support obligation.
Okay, well,
She transferred into a GED.
So Ms. Hawk just listed that as a thing, so we can bring that, that can be re-raised. I'm fairly certain that that's not accurate. And I'm also fairly certain that and I would hate for us to look into this, Ms. Petrie, that your client actually has access to Skyward right now for that student. So
not for Keelan. She does not.
Okay, that's great. I think that it's going to be an easy thing for this court to determine. All right, next.
There are just continuing issues with extracurricular activities and pick-up and drop-off times. So I guess I will just brief that issue in my motion.
There is a disagreement.
With some eye therapy that is being sought for one of the children.
Okay,
so those are the issues I'm identifying. I will file a motion.
Yes, file the motion. That sounds good. And then the other thing I want to say is, Dad doesn't talk to Keelan.
Keelan, no.
Keelan. All right. So,
Ms. Hawk, can I just interject for just 1 second? There is still the parenting coordinator on board.
Oh,
Your
very
client
well,
has an
yeah.
obligation to go through that parenting coordinator to resolve these issues. Has he done so? I
Yes.
believe he has.
No, he has. The responses do. I mean, we file the
Like,
Our Family Wizard messages with Judge Banfield every month, so she can review them. I mean, I'm happy to get in a battle about the details today if you want. I don't feel like it's what the court wants us to do.
I don't want to do it, and then I know Ms. Petrie, you're newer on the case, and I'm sorry you didn't get a continuance. So you're kind of getting that continuance now by us moving this out to the 16th. I will note that maybe interpretation is going to be an issue here, and you're going to want to look at some things before you decide that what your client's telling you is accurately fits into one category or
No,
not.
Your Honor, I've actually disagreed with the way my client interpreted the order, and I explained it the way I see it. So let me just tell you how I see it, and let me see if I'm correct. In watching the trial, it was contemplated that for extracurriculars, soccer specifically, that if mom was not available to do pickup after soccer, then dad would have the child, I guess, for an additional hour or whatever, and then they would exchange at 8 o'clock. Yes, but if mom was available to do pickup because her time started at 6:30, she could do so. Is that correct?
I don't know what we're doing right now.
I'd love to brief the issue.
I know, I don't even know what we're doing. I don't have this in front
That's
of me.
my understanding of the intention of the order.
I just was saying, I was making a very general statement, and so I don't know what this argument is because it hasn't been put before me. I'm sorry, I can't address this right now. Sounds like something. I can't remember that specific wording on the thing off the top of my head. That was, I wish I was that brilliant. But I'll see you guys back on the 16th, and you guys can file any motions regarding that. These things. All right, thank you so much. You guys have a good weekend.
Thank you, Your Honor.
June 16th at 9.
Yes. All right, have a great weekend.
Thanks, too.
In the rain.
Yeah.
Number 12 on the docket is the Weimer and Smith matter. Cause number 2230181606. I see Ms. Jovic and then Ms. Roberge. This is a motion for adequate cause. My understanding is that Dad has registered the parenting plan here in Washington with no objection. The kids are currently on a year-on, year-off schedule that's been very disruptive for several reasons. One of those reasons is just that one of the children's, you could consider somewhat special needs, needing a 504 plan or an IEP because of ADHD, which that alone would make it very difficult to adjust back and forth, let alone the other issues with the different levels of learning throughout the state. Sounds like there's been some domestic violence that occurred in mom's home. In fact, she'd had the children given to father during that time period, so that that issue could be addressed. And I didn't, Ms. Roberge, I'm so apologize. I didn't see a response.
Response, Your Honor, we had a whole packet delivered over to you, my assistant, or I should say my part-time assistant did. I'm sorry if you didn't get that.
I know, I'm sure it's my fault. It's still a surprise. I have.
Well, to be real honest with you, I had an ex parte restraining order sent over. It wasn't necessarily to your place, and the court lost it. So I just think at times things just get rerouted.
Yeah. So can you just give me your argument right now? That would be great.
Yes, Your Honor. This is a non-conventional situation. To make it real fast, in that my client totally agrees that Josh, the older child with the special needs, would do better in Washington with a stable yearly in high school. He has a good relationship with Dad, and we agree that it would be to his preference to stay in Washington. Now, the other child, the younger child, Caleb, that's a different story. He has a good relationship with both parents, and his verbal statement, and even in the declaration by the father, that he would like to go back and forth. Both parents are concerned with the jockeying year in and year out with them approaching high school. This situation, mom put forth a parenting plan. I mean, everything's on base, where she suggested Josh stay with dad and Caleb come back with her. Now, I appreciate that's unconventional, but in this case, it could be very beneficial. Caleb and Josh have a frictional personality relationship. Josh is the big brother, and he doesn't let Caleb doubt that for a moment. It gets down to the fact where Josh designates where everybody will sit in the car. I mean, it's very controlling. Caleb, with his mother, would have a chance to flourish, to come into his own, have his own desires, his own type of pattern, and not be under the control of Josh. And dad says, oh, I don't have that problem at my house, but you know, the letter that we submitted, that again is filed and on base, shows that Josh is making an apology to Caleb for hitting and hurting him. This is not a good relationship for them to always be together. They should be together at times, and that's why mom's parenting plan suggested that the children are together at summers, on spring break, and on Christmas break. Caleb, again, has a very good relationship with the stepfather, Stephen. They enjoy outdoor activities together, and they do workouts in the morning. They do errands together. It's a strong relationship. It's a very positive situation. As to the, quote, domestic violence, unquote, we would like to report and show those charges were dropped. And there was no, quote, prosecution. They had an on board, or whatever the term is, where the case was dropped.
Okay, well, okay. I'm gonna cut you off a little bit here. I understand what you're saying regarding the domestic violence. The fact that mom had said she felt unsafe, and I'm sure she did not further cooperate with the prosecution, which is why the case was dropped, which we know happens in domestic violence cases. But we know that she clearly felt like she was unsafe. And the boys indicated they did not have a strong relationship with him. So that part is still concerning to me. I will say that.
We agree with that Josh doesn't have a good, strong relationship with them. We agree with that.
It kind of sounds like we're just pushing one kid out, the one that doesn't fit in as well at mom's house, and keeping the other kid in.
Your Honor, I'll respond when counsel's finished.
It is, like I said, it's an unconventional situation.
I understand.
I do actually have a suggestion, and I'm following the Judge Gonzalez model here. When there is questions with the child, my last case, he actually ordered to have, and it was a 14-year-old child, go talk with Marty Dixon. And that actually could be an option.
Oh, you muted yourself, Miss Roberge. Miss Roberge, you've muted yourself. We're not hearing anything you're saying, and I'm getting tired.
Oh no, I got it. And I was having such a brilliant discourse. I don't know if you got back. I was mentioning about Judge Gonzalez.
About Marty Dixon. That's good. That's a good.
Marty Dixon. Okay. So what we're basically saying, it was a stressful situation where they were living in a camper while they were building their beautiful 38.
I don't need to hear any more argument. And you have great arguments, by the way. But I don't need to hear any more argument regarding. I understand that the family was under a stressful situation. I understand that this thing did happen. So it's frustrating to act like just because it was dismissed. But I understand, and I'm glad that you guys agree that the needs of the one child are significant, and we shouldn't be bouncing these kids back and forth. My understanding is that these parents came up with this decision together. I don't know that they had ever been parents before, and I don't think that they would have realized the impact it would have on the children. This is a motion for adequate cause, so all I have to determine today is whether or not there's adequate cause. I don't have to hear any more argument, right, on that.
We agree.
Okay,
We agree
great.
there's adequate
Thank you.
cause.
So the court finds adequate cause because there's been a significant change in circumstance. The children have gotten older. There has been some issues in the home. We have another child that has some educational needs that need to be met. So, Ms. Jovic, can you get me an order indicating I found adequate cause? And then we can move on. You can request trial dates from my, or request a set for trial, whatever, on the modification. So I don't need to hear any more arguments about what we should do at this time, because all I'm having to determine is what, if there's adequate cause at this time. That's what I think. Is that right?
Well, that's correct. I'm not sure if Ms. Roberge would want to have a temporary parenting plan put into place until then. We do have a proposed parenting plan that addresses, corporal punishment. And so for the remainder of this school year and until trial, we would request that both children remain here.
Your Honor, there's summer coming up, and the mother is entitled to have the children. She had the children last summer with her husband, and there was no complaint. So there's no reason not to have summer with the mother.
Okay, so
Well,
we're
so
gonna
that-
have to have
yeah,
another
that's-
hearing to address this issue, and we can do that one sooner rather than later in the interim. But I will say that, I know your client's gonna wanna address some of the issues that were raised by Ms. Jovic about these push-ups and these other things that are kind of seem extreme. Maybe these are not true statements. So you'll have an opportunity to meet those, but at this time, with the information I have, the court will entertain a new temporary parenting plan. That's specifically because that's one of the issues that I've determined adequate cause. One of them was the educational needs. The other was that the children, the age of the children and their needs not bouncing back and forth. And the other is the domestic violence and relationships within the mother's home. So those are my two reasons. So I would entertain a temporary parenting plan, but I want to do so with argument. I think school lets out around the 19th of June. I can't be really clear, but so I can give you, I can let you reach out to, I've got some special sets here. I've got a special set the morning of May 30th.
Ma'am, this is Elizabeth Smith, Josh and Caleb's mother.
Yes.
I just wanted to shine some light on the situation.
Yes.
Justin Weimer has already agreed to allow them to come on the 1st of July for the summer. And I purchased with my own money the tickets to get them here.
Objection, Your Honor. Counsel represents mother, so I prefer we hear from counsel. This is news to me, and I can't verify this with my client.
All right, it's okay. So you're saying this is July, Miss Smith. You're saying this is July, and so we have some time. I'm giving a special set date for this argument of May 30th, and we can argue the temporary parenting plan at that time. Does that work for everybody?
Yes, Your Honor.
Okay.
Yes, Your Honor.
9, yeah, she did, what'd she say? Yeah, morning, 9 a.m. Well, it's half day. And then,
What time on the 30th, Your Honor?
9 a.m.
Okay.
Okay, and then the other thing, is, Mom, so July 1st is not the whole summer, so that, what was the time that they were supposed to stay with you?
Usually with the old parenting plan, they would transition on the 1st of July and they would come back a couple weeks before school started. So I have not bought the plane tickets to come back because I wasn't sure of
Right.
what was happening.
So they would be with you for a little over a month.
6 weeks to 7.
Okay, that's okay. Cool. All right. So I just wanted to make sure because I definitely would want you to have some parenting time this summer, regardless even if I decided the kids were to be back at school in Camas. So I just, but we've got time to address that.
Your Honor, just to help with negotiations, would you clarify that basically what May 30th would be is for an interim parenting plan? This case needs to be set for trial. But if counsel and I can agree to a summer parenting plan, then we're good?
Well, depending on when
this
you're
will also.
depending on when you get a trial date, yes. Because if you get the summer, but then the kids have to come back to school. So if you got a trial date before the end of summer, which I don't know that you would, I don't know that
We
there's
would.
one
Okay,
available.
that's
So
fine.
if you guys,
All right.
if you guys can agree, I personally don't, and I know this wasn't the plan, Ms. Smith, I think it's not, I don't think that anyone took into consideration the impact this would have on children. I don't think that any child should be going a year on, year off at this age, so,
I totally agree now.
Yeah.
When we first came up with this plan in Virginia, we were both active duty
Yeah.
in both states.
it made sense, I read that, it made a lot of sense.
Yeah, and yeah, it just became apparent, and Josh has friends and has stability there, and Caleb should be warranted the same benefit.
Yeah, I agree, but that's like, now you're saying he should just go back and forth again, so now he's gonna start back and
no.
forth again.
No, we want him to stay in Florida, Your Honor.
I understand that, but what I'm saying is, he's currently where?
He's in Washington now.
That's
Would
what I'm
you
saying, so
entertain
you're saying,
before?
okay, yes, we should I want them to have stability, but we start the stability for next year. And so that part's a little odd to me. I mean, right now, he's in, it seems that we'd want to go forward, but I haven't gotten all the information. I'm gonna leave my mind open so we can address some of this on the 30th, and then the rest at the trial, okay?
Would you entertain having Caleb talk to Martin
Not at this
Gibson
point,
before?
not at this point. There's been no real motion for that, but I'm not ready to entertain that. If you guys wanna try to get a GAL on board right now, that might be better, but I know, I'm not gonna, I don't know. You guys can consider that together. All right, I'm gonna let you guys go, and I'll see you back on, May 30th.
Thank
Thank
you,
you, Your Honor.
Thank you, have a great weekend.
Too.
Is that docket complete? Oh, gosh, I'm late. All right, we can go on the record.